case number 15-005228-01-FH, People of the State of Michigan versus Virgil Smith. Appearances, please.
Good afternoon, Your Honor. Lisa Lindsay on behalf of the People of the State of Michigan, P number 39570.
Good afternoon, Your Honor. Godfrey Dillard appearing on behalf of the defendant Virgil Smith, file number P22802. Mr. Smith is in the courtroom.
Okay. All right. Mr. Egan, do you wish to put your appearance on the record?
Gerald Egan, P29182 on behalf of Mr. Smith, as co-counsel with Mr. Dillard.
Okay. And just to recap, I believe the last time we were here in court was on January 15th. Trying to refresh my memory. And I believe on that date, I can't remember if we were on the record that date or if you both came or conveyed that you needed more time because Prosecutor Worthy was out of town and unavailable. I just can't remember if we did that in court or if that was just pursuant to an order.
It was in court, Your Honor. Then it was followed up, I believe, by the order.
Okay. And then, so I had rescheduled it for February 5 of 2016. And then on February 4th, I was given a stipulated order by Mr. Dillard and Ms. Lindsay that I adjourned the sentencing from February 4th to February 11, today's date. I'm not sentencing, but the final conference. Is that correct?
Yes, that is correct, Your Honor.
Yeah, and Judge, it was due to the fact that I was in trial next door and I didn't have a chance to get with the defense counsel and hammer out some details.
And I know that I sent another order asking to get the settlement offer in writing yesterday, but I didn't receive it until just a moment ago. So I have it in writing. But the first thing I'm going to do is I'm going to ask Mr. Smith if he'll please stand and raise his right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may put your hand down. Tell me your full name, please.
Virgil Smith.
And how old are you?
36. How
far have you gone in school?
Master's degree in public administration.
And Mr. Dillard, and I guess Mr. Evelyn are your attorneys?
Yes, sir.
If you had a full, fair, and complete opportunity to discuss your case with them before coming into court today?
Yes, sir.
And you can be seated for right now. Thank you. And Ms. Lindsay, is there a plea agreement that the parties have entered into?
Yes, the people, there's no charge reduction as to count one. He will be pleading guilty as charged to malicious destruction of personal property, $20,000 or more. In exchange for that plea, the people will be dismissing count 2, felonious assault, count 3, felony firearm, and count 4, domestic violence. The malicious destruction of personal property is a 10-year felony. There is a sentence agreement in this matter. Would the court wish me to put those terms on the record at this point?
Yes, please.
Okay. 10 months in the Wayne County Jail, no early release, 5 years probation, resign the position as state senator. The defendant cannot hold elective or appointed office during the full pendency of his probation. Alcohol and drug treatment with monthly documentation. Mental health evaluation and full compliance with treatment with monthly documentation. Surrender the weapon that was used or indicate the location of the weapon that was used, and full restitution to the complainant to be determined by the court. I believe that is a full recitation of the conditions.
Okay. Was that the plea agreement, Mr. Dillard?
Yes, it is, Your Honor.
Okay. And, all right. So I have...
And for the record, the complainant has been informed of the plea agreement. We've had discussions with her throughout the pendency of the case, and she is here in court.
I have some questions that I want to ask before we go forward. And I guess let me start here, because I'm a little bit, the only way I'm familiar with the facts of the case is from reading the preliminary examination, which I read when the parties told me they were going to file a motion to quash, and I simply wanted to be ready when I got the motion. So I read it. And I note here that one of the requirements of the sentence agreement is surrender the weapon used, or I think you said reveal its location?
Yes.
Because one of the things that I wrote down as far as questions to myself when I read the exam transcript is what happened to the weapon? Because it appeared to me...
No, I was just getting ready to respond.
Go ahead, please do.
The weapon was not recovered at the point in time a search warrant was done on the home of Mr. Smith. Through investigation, we have learned, or we have learned that the weapon may have been disposed of in the location of where it was disposed of. They will, in fact, indicate to us the location that it was disposed for us to go to that point and try to retrieve it.
Okay. So, and there is a sentencing guideline that speaks to that, offense variable 19, is that correct?
Yes. I believe so.
Which refers to, I suppose, interfering or attempting to interfere with the administration of justice. Would that be the correct offense variable?
That is OB-19. That's correct, Judge.
Because based on my reading of the preliminary examination transcript and what Ms. Lindsay has just told me now, that in addition to the crimes alleged in the information, or the amended information, it appears that the gun was hidden. Is that a fair... Hidden?
Yes, that's a fair assessment. Actually, I believe it would be more accurate to say disposed of. It would be more accurate to say disposed of.
Because what comes to my mind is that when people get in trouble, that people make things worse with the cover-up. Is that correct? So that's what appears to be here, an attempt to cover up or to hide something relevant to the alleged offense.
I wouldn't characterize it in that manner, Your Honor. I would characterize it, given the medical conditions that are associated with this defendant, and the proximity of the offense and the state of mind at that particular time, that, I would characterize it more as panic or response to the conditions that he was suffering at that time.
Well, panic.
Pardon me, Your Honor?
Panic, I can understand.
Well, Your Honor, we certainly have, as a part of the negotiations, had extensive discussions with Madam Prosecutor about his mental condition at the time. And I'm sure that played somewhat of a factor in what happened here. So we certainly feel that his judgment was not good at that time for a variety of different reasons. So I wouldn't, as I said, I would rely on the fact that there was a certain amount of panic and there was certain conditions that he was suffering at that time that impaired his judgment.
With the court, we did indicate at some point that the defense was providing medical records and things of the like to have us evaluate what was going on. We're privy to some information in terms of the medical condition that you are not, that you probably will be privy to once you get a pre-sentence report.
Judge, I'd also like to add to the fact that, just looking at the exam transcript doesn't fully expose the court as to what happened. Certainly we have a statement that he made when he went into the police station immediately after this event, where he admitted what he had done. So, and that's after he had a chance to get himself together and make a proper judgment. So, the notion that he was running away from this particular incident, I think, is incorrect. He actually made a statement and admitted what he had done. And these facts go directly to what the sentencing agreement is dealing with right now. So, as I said, I just don't think that looking at the exam transcript alone adequately informs the court as to his mental condition at the time. And certainly post this event, he gave a statement to the police that he had shot the car.
I have another question. Were there any fire cartridge cases recovered from the scene?
There were no fire cartridge cases recovered from the scene, and through investigation we learned that somebody, we don't know who, but they were actually taken from the scene.
Okay.
Well, actually, I do have information that they were disposed of in some type of drain.
Has there been a determination at all as to how many shots were fired?
From looking at the car, I think you could safely say there was in excess of 20 bullet holes in the car. And we don't know whether in terms of in excess, one could be an entrance and an exit, so.
You know, am I recalling looking at the ballistics, I believe that there was in the proximity of 10 or 12 holes in the car. Now, if you're talking about coming in and out of the car, you know, I don't know what that is, but based on what the ballistics said, I recall it was 10 to 12 shots.
Sometimes the recovery of fired cartridge cases can add to the some sort of conclusion as to how many shots were fired. Not always accurate, but sometimes they can assist the people in coming to that determination.
Well, Judge, first of all, Judge, this was an extraordinary situation. You know, we're talking about 1 o'clock at night. We're talking about domestic situation. You know, there's blame to go around. But what I'm saying simply is that we have, he did admit that he had done it. He didn't dispute that. He gave that statement to the police. We have provided them with medical to substantiate that we feel that his judgment at that time was not up to snuff. And the idea that he's running away from this particular incident or attempted to run away was just discarded when he went into the police station and told them he did it.
Has there been a determination of what type of firearm this was? I know there was reference to 2 different types of firearms in the preliminary examination transcript, one being a old grandfather's rifle and one being an AR-15.
It is my belief the old grandfather's rifle did not, in fact, fire to do the damage, and I believe, based on the circumstantial evidence, there was an AR-15.
Yes, Your Honor. That other weapon was a result of a subsequent search warrant of the house. There's been no dispute from our side about, you know, the type of weapon.
So, obviously, as we know in our system of justice, the prosecutor has, whether it be the Wayne County prosecutor or prosecutor anywhere in this state or anywhere in the country, has tremendous power because they have the power to decide whether or not to issue charges, what charges to make, whether to charge anyone with a crime, whether or not to dismiss any charges, and the power of entering into sentence agreements with the defendant in a particular case. And the judge has to make a decision as to whether or not, when a sentence agreement is entered into, as to whether or not to accept or not accept the sentence agreement. And that's really the purpose of my questions, because the court wants to make sure that regardless of the sentence agreement that may have been entered into by the parties, that the sentence that the court pronounces is reasonable under the circumstances. So some of the things that I note that I thought about, in particular for this case, because every case has to be judged individually. But we know that Mr. Smith was a state senator, it still is at the time of this offense. And with all elected officials are expected to observe high standards of conduct, and that we know that the public confidence in our elected officials is eroded by irresponsible or improper conduct, and that public officials have to expect to be subject to constant scrutiny. So the question, I guess, one of my questions is whether or not public officials should be sanctioned or punished any differently than anybody else, and how does that weigh into the court's decision about what is a reasonable sentence?
Well, the court would be privy to this information at sentencing, but I can tell the court now that we received several medical records that indicated that defendant suffered from bipolar depression, and he was in perhaps a hypomanic episode during this time, that he had a neurocognitive disorder related to a traumatic brain injury arising out of a documented rollover automobile accident that happened in December 19th of 2014, and he was alcohol dependent at the time of this event. Those were the factors. I think more significantly, the untreated bipolar hypomanic disorder.
Your Honor, certainly Mr. Smith is being punished. Mr. Smith is being found guilty of a 10-year felony. Mr. Smith is being incarcerated. Mr. Smith is resigning his office. Mr. Smith has to undergo treatment for what he's doing. Mr. Smith cannot run for elective office again. The idea that Mr. Smith is being treated differently because he's a public official, given those facts, should certainly be diminished. If anything, in certain situations, it might be argued that he's being treated more harshly, and I certainly think what the court just said might be the suggestion that he should be. But I don't think anybody looking at what this episode will do to this young man's life, he's 34, 35 years old, somehow he gets a pass for what he did, especially given the circumstances that caused this particular incident. This was a situation where Mr. Smith was in his own home, sleeping in his own bed, and with someone else, and that was interrupted. So this is not a situation where Mr. Smith was out robbing somebody or stealing money. He's sitting in his home. And we all often can react in different ways in that type of situation. But the notion that he somehow is getting a pass, or somehow that he is not being severely punished, given the terms of this settlement agreement, I just think that that's unfair.
Well, I was simply asking questions for you to answer, to tell me whether or not you believe, understand whether or not this sentence agreement is reasonable, and whether or not you feel that any difference should be, there should be any difference or not when a public servant is the subject of a charge any different than anybody else.
Well, I think this public servant in this particular situation, given the totality of the facts, is being severely punished.
Okay. All right. So let me ask a couple other questions. The 10 months in the Wayne County Jail with no early release is just a 10-month jail sentence. Is that correct?
No, coupled with 5 years probation.
Okay, but there are programs within the Wayne County Jail, but he's not being attached to any of those programs. All the other conditions are conditions that he has to, I'm talking about the putting aside the resigning and cannot hold elective or appointed office, the alcohol and drug treatment and the monthly documentation and the mental health evaluation and the compliance with treatment. Those are all conditions that he's going to be ordered to fulfill after his release from the Wayne County Jail. Is that correct?
Correct.
Correct, Your Honor.
Okay. So the other question, and I asked this because I ask questions I don't know the answers to. And that's why I ask them. People that I know have good minds and share their thoughts and opinions with me and their perspectives. One is that Mr. Smith greatly benefits by the prosecutor's decision to dismiss the felony firearm charge, which would carry a mandatory 2 years in prison if he were convicted of that charge. Is that correct?
Yes.
That is correct.
Okay. And certainly, a plea of guilty to this crime would satisfy those elements. So it's not a question of dismissing that charge because the elements wouldn't be satisfied. It's a decision that the parties have entered into because they feel that it's a reasonable settlement. Is that fair?
Yes.
Yes.
Okay. So, there are jail sentences that sometimes that the courts give that have fashioned with the cooperation with the prosecutor's office, such as the domestic violence prevention program. There's a drunk driver reduction program. There are other programs that judges with agreements with the prosecutor sentence people to where they serve a jail sentence and they receive certain type of treatment or participate in a certain type of program. This is not such a sentence agreement. And so we know there's a consent agreement that the County of Wayne has entered into with the state treasurer because the county is in a financial emergency. So if anyone who serves a sentence then in the Wayne County Jail, that jail time is paid for, comes from the general fund from the County of Wayne. Is that correct, Ms. Lindsay and Mr. Dillard?
Judge, I'm not privy to, I have no personal knowledge of the inner workings of the jail and the financing of the jail. I have to be honest, I don't.
Okay.
Judge, I haven't done cases that really involve jail time and ages. Most of my cases are murders and involves prison time, so I can't speak to county jail time.
So it's my understanding that when people are incarcerated in Wayne County Jail, that comes out of the general fund for the County of Wayne. And when people are incarcerated in the Michigan Department of Corrections, it comes out of the state treasury, the state budget. So it comes from a different source. So I guess the question that I'm inquiring or asking about here is that in light of the fact that, and I'm just asking because I'm interested in your perspectives and whether or not anybody thought about this before, because I know I'm always thinking about this, because we know that we have limited sources of funds, and we want to make sure that our whatever sentences we make are fair and just, and the best use of whatever limited resources we have. In light of the fact that this is a straight 10-month jail sentence, I mean, plus probation otherwise, is it a good use of funds to have Mr. Smith incarcerated in Wayne County Jail as opposed to the Department of Corrections?
Yes, that's a policy question, okay? I think
so
that...
So you're saying I should probably more...
Well, no, what I'm saying is, Judge, is that the statute set forth what the sentence should be for a person. The statute sets forth what the guidelines are, and I think the judicial system should focus in on that. The policy issues about how people are, how we pay for incarcerated positions, that's for the legislative branches to deal with. As of right now, that has not been set forth in any sentencing guidelines. That has not been set forth in any statute that I know of. And although that may be a concern for conjecture or consideration, I just don't think that has its place at this particular point. We have a defendant here that has admitted to the crime, is accepting the sentence within the statute, that his sentence is certainly within the guidelines. Whether or not the policy decision that we should pay for, criminal defendants who are incarcerated should pay for their sentences. I just don't think that that's an issue that is appropriate, just in my opinion.
I guess what I'm asking is that, reasonable people can differ about what a reasonable sentence is. This sentence may be reasonable, certainly the parties believe so, and I haven't made my decision on what I'm going to do at this particular time. But certainly sometime a prison sentence might have been reasonable under the circumstances as well. And so all things being equal, in light of this particular jail sentence being a straight 10-month jail sentence with no other programs within the Wayne County Jail attached to it, I'm simply asking whether or not why the jail sentence, why would that be reasonable under these circumstances as opposed to a Department of Corrections sentence when all the other requirements are simply being done as a condition of probation. There'd be no probation, obviously, with a jail sentence, but they could be a condition of both.
Well, Judge, I just don't think the court has had the opportunity to review what the medical condition is here.
Okay.
You certainly, I certainly understand the court looking at the factual situation and your concern, but based on our negotiations for well over a month, I don't know how long we've been negotiating, almost back from the very beginning, the court knows that I filed a certain defense related to this case. And I think that the totality of the facts, how this incident occurred in his home with a female, entering his home at 1 o'clock in the morning, coupled with the fact that he had been a closed head injury within a reasonable time prior to that he had some alcohol dependency, and he had some psychiatric issues that were in play, which have been fully documented by a psychiatrist. We felt, looking at the totality of the circumstance, and the prosecutor, not just Ms. Lindsay, but Kym Worthy as well, felt that on the totality of the circumstances, taking all of that into consideration, this was a reasonable resolution of this matter. And what I'm saying to the court, that's why we think that this is a reasonable sentence. It's just not the facts of the case. It's the totality of the facts.
Ms. Lindsay, did you want to respond to my last question? You understand it, don't you?
Not quite, but...
I'm simply asking, when there's limited resources available, and whether or not any consideration is given, or what impact or how you factor in the limited resources that may be available between agreeing to a jail sentence or agreeing to a Department of Corrections sentence, when the jail sentence is simply a straight 10-month jail sentence, as opposed to a jail sentence with a program maybe in the Wayne County Jail, such as a drunk driver reduction program. A jail sentence can be, but a drunk driver reduction program, for instance, or a domestic violence program or mental health program within the jail, the inmate is participating in a treatment program while they're there. Otherwise, it's my understanding it's just empty time.
Well, in terms of my analysis, in terms of the use of resources, really had to do not so much with the jail time, but with the time in terms of trial time and the amount of resources that would be devoted to this, as opposed to resources devoted to somebody who posed a greater danger in the community. Surely Mr. Smith was a danger on that night when he fired those bullets. But in terms of my analysis, when I was thinking about it, I was thinking in terms of limited resources and devoting to trying other cases. There are certainly more dangerous people in the community, or more dangerous people that resources should be devoted to taking care of. So in terms of the amount, the resources of the county jail, that didn't factor into my analysis in terms of when we were discussing this plea. And as the court knows, you're a prosecutor just like me. I don't make the decisions. It's above my pay grade. I speak with my boss. There's interaction between defense counsel and everybody, and ultimately, a decision was made.
Right. But I can only ask the questions of the people that are in front of me.
I understand
And
it.
you as the prosecutor's representative get to be asked the questions.
I understand.
All right. All right. Well, I think Mr. Dillard brought up a very important point in terms of the amount of time. He mentioned that they spent in negotiations with the prosecutor. And I know that Mr. Dillard mentioned, either on or off the record, that one of the things that he was doing during these negotiations was preparing in addition to the evaluations that Mr. Smith may have undergone, is preparing a memorandum for Prosecutor Worthy. Did I understand that correct?
Yes, we did. Yes, we did present a written memorandum.
And I obviously have not had the benefit of receiving that memorandum, but I'm confident that even if I didn't ask for one, but I will ask for one, that I expect that the parties will provide a memorandum to me prior to sentencing, so that I have the same benefit, so that at the time of sentencing, I can make a decision as to whether or not I wish to accept or reject the offer or the settlement agreement as to whether or not it's a reasonable sentence under all the circumstances. Is that fair?
Just have a moment here.
I understand that you may not want to present everything to me that you presented to Prosecutor Worthy in the issue of confidentiality. I understand that. And in some cases, when prosecutors and defense attorneys enter into plea agreements and dismiss charges or enter into certain sentence agreements, it's readily apparent to the judge, even sometimes without knowing more, as to why they're doing that. For instance, in this case, I can, having read the transcript, I understand the issues that Mr. Dillard has raised, that there's a difference in the I suppose, the strength, perhaps, because of what a trier of fact may do with regard to the domestic violence count or the felonious assault count. I totally understand that, and I get that.
Additionally,
but there's things, so I understand why those charges might be dismissed. I can get that right off the bat. But there's other things that I'm not privy to, that the parties are privy to.
yeah,
And I still need to be persuaded, because I am ultimately the one that has to make the decision as to whether or not to accept or reject the agreement, or what the sentence will be.
Well,
That's my role.
Okay, one of the things I know the court, we had a lot of back and forth, and I have filed a motion to demand the download of, or the turning over of Mr. Smith's phone as it relates to get information about what went on. Through the download of the phone, there is a lot of information that could be proved. The press is here. And in the event that there's a trial, maybe some information that comes out is an embarrassment both to the victim as well as the defendant. And in the days of the internet, something can come out, and 5 years down the line, it shows up on the internet. If there's a trial, there is some materials that may be exposed that could prove to be detrimental to people's how they're perceived by other people who may see this information online. That's one of the considerations also when you're talking about resolving a matter, because it's just not a simple matter of, you come in, you have testimony and things of that nature. What is put out on the internet, is put out in the media, lives forever.
Okay. So,
there are a multitude of reasons, and if the court wishes, we could.
I guess what I'm concerned about, Judge, as we stand here is we have an agreement, and then I'm going to allow my client to make certain statements and say certain things, and the press is here, and it's going to be reported tonight in the paper and probably tomorrow. And then we're in a situation where whenever the court sets the sentencing agreement, and then the court may, I don't know where the court is going on this, maybe the court will accept the plea, maybe it won't. It's saying it hasn't made up its mind.
I'm not supposed to make up my mind until the sentencing is hearing and after the defendant has had an opportunity to allocate.
Well,
correct?
Well, Your Honor, that may be the technical way in given most cases, but we're not dealing with a normal case here.
Okay.
We are not dealing with a normal case here. Now, I mean, I think that there should be, if the court is going to reserve judgment on accepting this settlement agreement or not, there's some adjustments that we can make to protect the defendant from further tainting of the jury pool that may come as a result of this if the court decides not to accept the plea. I mean, if the court wants to have us give him the memorandum and you review the memorandum and then at that time make the decision whether or not we should elocute on the plea, that certainly would be helpful. But to have us stand up here and make statements in front of the court with this array of media people here, it's going to taint the jury pool if this court decides not to accept this plea. It's not a normal case. We normally wouldn't have 1, 2, 3, 4, 5, 6, 7, 8, 9 media people sitting here focused in on this matter.
Well, I haven't made any decision. I'm not supposed to make any decision at this time. I just want you to know, as I've indicated, that there's questions that I have, and I wanted you to know what those questions were and give you the opportunity to answer them. And if Mr. Smith decides to go forward today, I'll simply only be asking him about the elements of the offense, and then I'll want sentencing memorandums before sentencing for me to review. Sentencing memorandums are not unusual. I've asked for them in many cases, and that's why I'd be asking for it here.
Yeah, and the press is going to report that Mr. Smith, on this particular day, at this particular time, pleaded guilty to these charges. And that's going to be all across the paper tomorrow, on radio, on TV, and I'm saying that puts us in a position where we're tainting the pool. Now, if the court, let me make it clear to the court, I have no problem with the memorandum.
Good.
None at all.
Good.
Now, if the court wants us to give that memorandum and set another date, and we come back and the court reviews that memorandum and we start on that particular day, I have no problem with that. But I do have a real serious problem with Mr. Smith's rights to be presumed innocent, and we've got this kind of media attention here being tainted. And I'm not trying to stop the court from doing it. The court's going to do what it wants to do. I understand that. But I'm saying there has to be some recognition of reality. This is reality. This media thing over here is reality. The court doesn't normally deal with this on a sentence of this nature, malicious destruction of property. No, it does not. And so we must have some adjustments to protect this man's rights. He is being punished. He's accepting it. He doesn't, and if the court is not satisfied that this was a reasonable negotiation between Prosecutor Worthy and I, and that we did not present medical in the medical record, I don't think Prosecutor Worthy would have entered into this agreement. She's an experienced prosecutor. She understands the totality of the facts of this case.
But it's still my decision.
I understand, but I'm trying to protect his rights given this media exposure over here. That's what I'm trying to do. I don't want him, and if this court, out of your good judgment, and that's your judgment, decides you don't want to accept the plea, we can live with that. If that's what your decision, we have to live with it. But in the interim, I don't want Mr. Smith, his rights to a fair trial jeopardized by this media exposure that we're going to get today.
I really don't understand what you're saying, because
they're going to report what he says, Judge, today, on the news, tonight, on the radio, tomorrow.
And that happens, well.
But we don't have a situation where at the time of sentencing after that, I don't think it's normal that the sentences could be rejected after that kind of media exposure. I don't think that that's normal.
Well, one, the court rules talk about that when I advise Mr. Smith of his rights, if he chooses to plead guilty, that if at the time of sentencing I decide not to accept the sentence agreement that's entered into by the parties, I would allow him to withdraw from his plea of guilty. And that is the same advice I give in every single case.
Well, I'm asking this court.
And I've rejected sentence agreements in the past.
Yeah.
Not many, but sometimes. And this is a very important case. You recognize, we all recognize that there are special circumstances, that being that Mr. Smith is a public official, and I want to make sure that the sentence here, or that any sentence I impose, whether I adopt the sentence agreement entered into by the parties or not, is fair both to Mr. Smith and to the people of the state of Michigan.
And that's what I wanted to be fair to Mr. Smith, that his right to have a non-tainted jury pool be protected.
So what are you asking?
I'm asking for the court, if the court wants a memorandum, we will present you the memorandum, and you can look at the memorandum to get the facts that you feel that you are not aware of. And then you can if you are satisfied with that, we can come back at that time, and and if the court is going to accept it or reject it, if you're going to reject it, it won't matter at that point. But if you're going to accept it, we can elocute on the plea agreement at that time. Because the court is just claiming I don't have enough information. Well, why don't we delay this matter and give you the information?
No, I set earlier dates as the date, the last date.
But I didn't know that the court has this much concerned about whether or not this is a reasonable agreement. We didn't come in here with the thought that this court would be this concerned about a negotiated settlement agreement over months between not just Ms. Lindsay, but the prosecutor, and the totality of the facts of this case. And the fact that the senator, had made a statement to the police about this particular, and he's pleading guilty, that is not being, and he's being punished.
Well, lawyers always know a lot more about any case and everything behind it than the judge does. And I'm just asking to be brought up to speed so I can make an intelligent decision at the time of sentencing.
I have no problem with trying to bring the court up to speed, but I would ask that let us bring you up to speed and then let us come back.
No. Okay, so I'll expect the sentencing memorandum, and depending on the date I set, I'll let you know when that's due. Does Mr. Smith wish to go forward?
we're ready to go forward.
Okay.
All right, so I think I left off, and Mr. Dillard and Ms. Lindsay have both agreed that the plea agreement that was put on the record by Ms. Lindsay is in fact the plea agreement that was made or offered. So, Mr. Smith, did you hear and understand the plea agreement that has been placed on the record by the lawyers?
Yes, Your Honor.
Is this what you've agreed to do?
Yes, Your Honor.
Do you ask that I accept this plea agreement?
Yes, Your Honor.
Are you presently on probation or parole?
No, Your Honor.
Okay. I have to go over the charges that are in the amended information. In count 1, you're charged with malicious destruction of personal property, a value of $20,000 or more. That carries the maximum penalty of 10 years in prison. Do you understand that?
Yes, Your Honor.
In count 2, you're charged with assault with a dangerous weapon. That carries the maximum penalty of 4 years in prison. Do you understand that?
Yes, Your Honor.
In count 3, you're charged with weapons felony firearm, which carries a penalty of 2 years in prison, which must be served consecutively with and preceding any term of imprisonment imposed for either count 1 or count 2. Do you understand that?
Yes, Your Honor.
And in count 4, you're charged with domestic violence, which carries the maximum penalty of 93 days in jail. Do you understand that?
Yes, Your Honor.
And the prosecutor has said it'll dismiss counts 2, 3, and 4 in exchange for your plea of guilty to count 1 with the following sentence agreement: that I sentence you to serve 10 months in the Wayne County Jail with no early release, that I sentence you to serve 5 years probation, that you resign your position as a state senator, that you cannot hold elective or appointed office during the full pendency of probation, that you must comply with alcohol and drug treatment and make monthly documentation, that you must submit to a full mental health evaluation in compliance with any treatment with monthly documentation, and you must surrender the weapon used, and that full restitution will be determined by the court. Do you understand that?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
I have one question, Your Honor.
Go
As
ahead.
to the surrender of the weapon, as indicated, we will indicate where the weapon was disposed of.
Well, I think that Ms. Lindsay indicated that she understood that the two of you were in agreement as to what compliance with that requirement is.
Yes.
Just want to make sure it was clear.
Okay, all right. No questions, right, Ms.?
No, Your Honor.
Okay. With all that in mind, how do you plead to count 1, malicious destruction of personal property, a value of $20,000 or more?
Guilty.
If your plea is accepted, you will not have a trial of any kind, and so you're giving up the rights you would have had at a trial, including the right to be tried by a jury, to be presumed innocent until proved guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at the trial, to question the witnesses against you, to have the court order any witnesses you have for your defense to appear at the trial, to remain silent during the trial, to not have that silence used against you, and to testify at the trial if you want to testify. Do you understand each of these rights?
Yes, Your Honor.
Do you understand that if I accept your plea, you'll be giving up every one of these rights?
Yes, Your Honor.
If I accept your plea, any appeal will be by leave of the Court of Appeals. That means there's no automatic right to appeal. Instead, you would have to ask the Court of Appeals to hear your case, and the Court of Appeals would decide whether to hear your case. Do you understand that?
Yes, Your Honor.
Now, I'm holding up a form titled Settlement Offer and Notice of Acceptance. I believe the pink carbon copy is on the table right in front of you.
Yes, Your Honor.
Is this your signature in the lower left-hand corner of this form?
Yes, Your Honor.
Have you read and do you understand this form explaining the rights you would have had at trial that you're giving up by pleading guilty?
Yes, Your Honor.
Do you understand you're giving up every one of the rights described in this form if I accept your plea?
Yes, Your Honor.
There are some claims you'll be giving up if I accept your plea. You'll give up any claim that your plea was the result of promises or threats that I'm not told about today, and also give up any claim that it was not your own choice to plead guilty. Do you understand that?
Yes, Your Honor.
Do you understand that I'm not bound to follow the sentence agreement that you've entered into with the prosecutor, but if I choose not to follow it, you'll be allowed to withdraw from the plea agreement? Do you understand that?
Yes, Your Honor.
Now, there's one caveat to that, and I talk about that with any defendant who pleads guilty, whether out on bond and where the sentence agreement or preliminary evaluation of sentence includes either a jail term or a prison term. I say, because I've actually had the experience where someone said to me, Judge, I'm out on bond, I know I'm going to jail or prison, I don't remember what it is, I've got nothing else to do, I want to start serving my sentence today so I can get it over with sooner. And I said, okay, we can accommodate you on that. Most people say to me, Judge, I know I'm going to jail or prison, whatever the case may be, but I have some things I need to take care of before I start my prison or jail sentence, whatever the case may be. And there are many, many valid reasons why people need time. And I listen to what everybody has to say. And I say, usually I say, that's reasonable. We can pick an agreeable time for sentencing or whatever the case may be. But I tell people that, as I tell you, if you choose to stay out on bond until sentencing, if you violate the conditions of your bond or pick up a new case, that at the time of sentencing, I don't have to follow the sentence agreement. And if I didn't follow it, I wouldn't have to let you withdraw from your plea agreement at that time. Do you understand that?
Yes, Your Honor.
Is that reasonable?
Yes, Your Honor.
Have you discussed with Mr. Dillard whether or not you'd like to start your sentence today or whether you'd like to remain on bond until sentencing?
I have my official resignation next week. Yes, Your Honor.
You'd like to stay on bond?
Yes, Your Honor.
Okay, very well. Okay. Other than what we've said in court today, has anyone promised you anything if you plead guilty?
No, Your Honor.
Has anyone threatened you to get you to plead guilty?
No, Your Honor.
Is your own choice to plead guilty to this offense?
Yes, Your Honor.
Are you pleading guilty because you are in fact guilty?
Yes, Your Honor.
On or about May 10 of 2015, were you at 18601 Wexford in the city of Detroit and county of Wayne?
Yes, Your Honor.
Okay. And was there property there that belonged to another person?
Yes, Your Honor.
Okay. And who did that property belong to?
And Miss Thomas.
Okay. And did you destroy or damage that property?
Yes, Your Honor.
Okay. And then at the time that you did this, did you know that it was wrong?
Yes, Your Honor.
All right. And when you did the act that damaged or destroyed the property, was it your intent to in fact damage or destroy the property?
Yes, Your Honor.
Okay. And I don't know if you know this personally, but was the extent of the damage $20,000 or greater? Maybe the parties know, or the parties willing to stipulate to that.
We will stipulate that the value was greater than $20,000.
We will stipulate for the purpose of the plea.
Okay. And you agree with that stipulation, Mr. Smith?
Yes, Your Honor.
Okay. And it's true that you did this with a firearm, is that correct?
Yes, Your Honor.
Okay. Ms. Lindsay, do you feel that the elements of the offense that Mr. Smith has pled guilty to have been fully covered by his statement of facts?
I do.
Do you, Mr. Dillard?
I do.
Okay. Are either counsel aware of any promises, threats, or inducements related to Mr. Smith's plea other than those already disclosed on the record?
There have been none.
No, Your Honor.
Okay. Is the court fully complied with the court rules?
People satisfied.
Defendant satisfied, Your Honor.
The court believes, once again, Mr. Smith, how do you plead to this crime?
Guilty.
The court believes that Mr. Smith's plea is understanding, voluntary, and accurate. The court is also satisfied there is a factual basis to support a finding that you are guilty of the crime of malicious destruction of personal property of the value of $20,000 or more. The court will accept your plea of guilty, and we will schedule a sentencing date. Okay.
Your Honor, can we be heard as regard to the time for sentencing?
Yes.
I had spoken with Mr. Smith about this, and I think he would, 30 days?
Yes.
We would request at least 30 days, Your Honor. He has some matters, the legislature and some other things that he needs to get in order before he voluntarily turns himself.
Okay. It is February 11th now. You wanted, well, I'm looking at March 14th in the afternoon. I will not be in the building in the morning, but I will be in the afternoon.
That's good for me, Your Honor, March 14th in the afternoon.
You want to do it at 2 o'clock?
Fine with me.
That's good. Judge, would the court prefer to do the restitution hearing at that point in time
Well,
also?
do you think you're going to be able to agree on the restitution amount?
We may. That's something we could talk about. The victim is here. She's been submitting documentation and bills to me all along, and I think we can sit down and try to hammer something out. But if we cannot, we may need a hearing.
All right. So I should give you, obviously, the opportunity to see if you can resolve it.
Yes.
Yeah, and Judge, I just want to say, we really haven't focused in on that. I mean, that was something that if we decided to go to trial, I was going to, I have some target people that I was going to depose and some things, and subpoenas I was going to set out to deal with that. But I have to be honest, I didn't really look at that at this point because I was more concerned about seeing where we had a deal. So I'm not, I'd rather, she probably has some things that I haven't seen. So I think we might be able to work it out. I just haven't had a chance. And I think we will work it out. I know I do.
If you can't, let me know, and we'll figure out whether to do the restitution hearing on that date or another date.
Okay, thank you, Judge.
And I would like the memorandum, whether you file one jointly or each file your own. Today's the 11th. Is it reasonable for me to expect it by the 26th of February?
The only issue, I'm sorry.
I'm starting a murder trial next week, so I doubt that I can get it to you by the 26th.
Because, I understand, I'm sure that my questions to you both probably, maybe they were unexpected, but I think, I don't know Mr. Dillard near as well as I know Ms. Lindsay or Mr. Evelyn, but I think they both know that I like to be thorough, and I like to think things through. And that's why I wanted the plea agreement yesterday, so that I could know ahead of time, what to think about and what to ask.
I certainly respect that, Judge. I want to make clear, my comments to the court is not in any way to give the suggestion that the court is not doing its job.
Okay. All right, so when do you think you can have this, Mr. Evelyn?
Your Honor, I need to have some clarity as to how much confidential information you're going to ask us to provide and how you intend to treat that, because as you know, under state rules we cannot routinely file memorandums under seal like we can in federal court.
All right.
As a consequence of that, because there's been dialogue about a number of variables that are not covered routinely in a sentencing memorandum unless they're filed under seal, Ms. Lindsay, my esteemed colleague, Mr. Dillard, alluded to the fact that there's information involving there's a sense of a sensitive personal nature, not just that it involves these individuals, but third parties. So we have to make a decision about how much of that is relevant for purposes of your consideration, and if we present that to you, in what form? In camera? Are you going to make arrangements for this to be sealed? Or are we going to have to make a decision to hold that back from you?
Right. I guess, I don't know the answer to the question, first of all, although I did think about it beforehand.
Well, but when you indicated that you get sentencing memorandums, and I filed them in almost every significant case, even in state court, but there's a decision made beforehand about how to deal with confidential information.
Right, and I guess that's the first decision that the parties have to make, of what is it that we need to reveal to the judge, to let the judge know that this is in fact a reasonable agreement that's fair to Mr. Smith and the people of the state of Michigan. I guess take one step at a time, right? Or if look into the fact, it's hard to know what we're talking about since you know and I don't know, but I don't know of any provision that at this point, I don't want to tell you to submit it to me under seal when I don't know that there's a way that I can keep that under seal. If there is, let me know.
Well, it's a very difficult process in state court. I've had to do it a few times in this building. And as you know, I've been trying cases in this building since 1979. And this is an extraordinary request from a court under the circumstances, not for purposes of a sentencing memorandum, but under these circumstances. So we're going to need some clarity, just that's all I'm saying. Because when I talk to Ms. Lindsay, we're going to make some decisions about confidential information. And the question is going to become how much of it should be given to you, and if any, how to provide it.
Okay. Well, I'll let the two of you work on that first, and then let me know if you need further guidance.
All right.
Yes.
Fair enough?
I'll talk to Ms. Lindsay, and then we can make a decision.
Okay. All right.
Can we have, like I indicated to the court, I'm going to be starting a murder case next week. Can we have March the 1st for the memorandums?
Yes.
Thank you.
Okay, all right. Mr. Smith, I think we need to give you some documents before you leave. So if you can just have a seat, come back in the court in a couple minutes, okay? All right.
That's March 4th, March 1st.
March 1 for the due date.
Okay, thank you, Your Honor.
Thank you.
Remember to bring a copy to me, Mark Judge's copy, so I'll make sure I see it.
For the memo?
Hold on.
Yes.
Yeah, well, of course, depending on, if we have to file under seal, we'll have to bring it here anyway.
Well, right. I'm assuming at this point that that's not the case. If that's going to be the case, then we'll deal with that.
All right.
All right?
All right.
Get a report done.
Closed right now, so tomorrow you'll just have to come here at this address, Clinton Street, it's right around the corner, and you'll just have to give them this, okay?
Okay, we'll do that tomorrow. Okay, sure, thank you.
And for the meeting, back up when you're all ready to go, I'll swear you down.